Welcome back, everybody, to the tentacles of Cuyahoga County. I am your host, the infamous ex-chief of the city of East Cleveland. It's the week of June 24th, and I'm learning. So I'm trying to set up a possible live event that I was going to go live for with a special guest that I'm having here coming up next month. And in doing so, I was playing around with the live settings and didn't realize that some of my recordings were going live when I've been interviewing people. So some of you may have a sneak peek into some episodes ahead. I was actually sort of surprised at how many views I got going live. I'm like, hey, it's Monday at 10 o'clock. Nobody's going to have seen those things. And I go in there and there was actually quite a few views. So anyways, some of you are going to have some sneak peeks in the coming up events on the channel. Good for you. Maybe I should start that Patreon channel. I don't still know how that works, but maybe I should. Anyways, we're going to continue. We're going to wrap up our interview with, and I call him Bob. That's why I keep saying Bob, the Robert Grundstein, the author. And I actually had to sort of apologize because I didn't realize that he actually has several books that he's written. But anyways, we're gonna conclude that coming up. And I realized that I cut him off real early, and I apologize for that. Again, I have a very dominant SEO manager for this channel. And I'm trying to keep him happy. Because the whole goal of this channel is to get as many viewers as I possibly can to educate everyone so that they can possibly see all the corruption that's going on, which is somewhat scary. And again, I still want to point out the good things that law enforcement's doing out there. I don't think, I mean, there are corrupt cops. There are. But I think the majority of cops go out there and try to do their job the best that they can with the small minutia of some backing from their department, which definitely there's no backing in Cuyahoga County anymore. Again, I feel bad for anybody living in Cuyahoga County because you have no backing for any of your law enforcement up there at this point. So we left off with Bob, the Robert Grundstein. He was actually just talking or explaining about how he got labeled a Virtuous. Hopefully I'm pronouncing that correctly. Litigator, which is a term that I actually just came up to know, not up with, but I just came to learn myself not long ago. I had never heard of that before. And I've actually heard it several times now. And they actually have a list on the Ohio Supreme Court. I was able to find it. It's not a huge list. There are several names on that list. And it's sort of odd to me how you can basically take the constitutional rights of a person away, especially any court. You would think that any type of proceeding like that would actually have to go through different proceedings. And for one common police court to be able to impose that on somebody for all 88 counties, again, it's quite alarming. But anyways, Bob was just talking about that when we were wrapping up with him, about how he got that label when he was actually in a lawsuit for his mother, and the attorney that was representing, or the defendant in that case, essentially, had just filed a motion against Bob, and for some reason the court awarded the attorney the ruling on it. But that's where we left off. His story is still very much enthralling. Trust me. It's mind-boggling to see that these things happen to pretty much everybody. And what everybody has to understand, if this stuff is happening to attorneys, police chiefs, It can happen to you, and that's what's scary, because when it does happen, it's mind-boggling that it can happen, period. But anyways, we're going to get back into, I might have one more segment, real quick segment, if there's any updates in between now and the time that I do the editing. I know that we had a officer-involved shooting, I think it was actually last week in Wadsworth. I honestly, I did not go very in-depth into the reporting of that because, again, Northeast Ohio's media outlets, the fourth estate of Northeast Ohio, is just as corrupt as the Cuyahoga County Prosecutor's Office. And I don't trust their reporting whatsoever. But anyways, from the reporting that did come out, it basically sounded like it was some sort of suicide by a cop. And that's what's exciting, and I'm afraid to say it because the last time I said it, it didn't happen, but this is where I'm going to be excited because, again, the event next month, I'm hoping to have a special guest on, an expert folks in the use of force of Ohio. He's actually an expert in several things, but one of the things is use of force, and I can't wait to have him on. And we're going to actually have a special edition. We're going to be we're going to be smoking cigars. So I don't know if you, the viewers, are able to smoke a cigar or not with us. Maybe don't smoke, and that's perfectly all right. Also, I'm not trying to elicit anyone into smoking that doesn't already smoke, but I do smoke cigars. My expert smokes cigars, so we're going to be smoking cigars, and I'm playing with the idea of making a live recording, but I'm not certain yet. But anyways, might be a shorter segment coming up, don't know, but we're going to get back into it again. You're either going to see some counting numbers going down, which would lead us right into the interview, or there might be another short segment. The surprises of this channel are just phenomenal. All right, we'll see you.
And I said, well, even though it's even the code for gun storage had three subsections, A, B, and C. They left out the C on mine, but it didn't make a difference because they're all misdemeanors. So in green ink, I added the C on the court order, sent them a letter and said, they left out the C. Here's the copy of the original statute with C. On my order, I just added it in green ink and wrote them a letter saying, oh, by the way, I added the C myself. It's not a fraud. I'm not changing a felony to a misdemeanor, and just to help them see things. So they got it, and they said, well, we see you wrote on the order, but it doesn't matter. You can have your gun. Go buy your gun. So I went and bought my 9mm. So I wrote on a court order in 2003, but I did not alter it in terms of in terms of creating a fraud. I just corrected it, and I wrote on it, in Vermont. So that event's very significant. Now let's go from 2003 when I got my gun and sent them the order in which I wrote in green ink with a letter accompanying the order, pointing out that I wrote in green ink. I mean, who else wrote in green ink? I didn't send a copy. I sent them in green, with a subsection. So in 2007, I was having trouble with a condominium ownership. Chagrin Falls, they were the Owners Association, managed by a guy named Fred Agresta, had charged the condominium owners $150,000 for a roof. And I said, wait, I know roofers. I spoke to them. They said the job's only $75,000, $80,000. So I called the roofer who did it. I actually found the roofer and I said, how much did that job cost? And he goes, $75,000. So this is fraud. I mean, I knew it. Agresta's reputation is terrible, just awful. I had this, evidence that he charged us $150,000 because they do a charge. It's very well documented, amended in papers to the condominium. So I sued him in Bedford Municipal Court. It's called a derivative suit, which you're filing for the benefit, the welfare, financial well-being of a nonprofit organization, the Owners Association. So I got Peter Junkin, Bedford Municipal Court. I had no idea how bad Bedford Municipal Court was. So anyway, Junkin, I come in from Vermont for hearing. They have a local attorney. Junkin's falling all over this guy, the local attorney. He didn't even know the file. He was shuffling through it, finding something, to criticize me for. And he dismisses the case. I said, Your Honor, well, why are you dismissing the case? There's no basis, in Rule 12. We haven't done discovery. Just no procedural or factual basis. And he goes, well, thank you for coming, Mr. Grunstein.
I mean, has there been any communication up to this point with you whatsoever prior to him dismissing, or? No,
it was a first hearing.
Okay.
Now, it is possible to have a case dismissed very quickly. In Rule 12, there are all sorts of vehicles for dismissing a case very quickly. But this case, met none of the criteria for the Rule 12 motions, like failure to state a claim, absence of subject matter jurisdiction, absence of jurisdiction over the person. There was nothing, we should have. But in Cleveland, where the judges are elected, they're always falling over local counsel. You're just not going to win. Plus, I had no idea how bad Bedford Municipal Court was. I mean, the former law director there, a guy named Tommy Longo, was arrested a couple of years prior on an international warrant in Mexico. There were gun violations. He was dealing drugs with the guys in Little Italy. He was convicted of date rape, giving girls roofies and then, violating them sexually while they were unconscious. And, this is the law director prosecutor in Bedford Municipal Court. And then, then it got worse. I mean, after, but I just had no idea how bad it was. I just had no idea. So I read an editorial about how bad Peter Junkin was. How he was slovenly. But in legal criteria, it wasn't just name calling. It was talking about, how he violated legal standard. And how, the design deficiencies of Ohio's legal system, especially where, judges are elected, have to be exposed and discussed. The legal system hasn't become, the trustee of ethical behavior. What it's become is an interest group where, partisan participants distribute income among one another at the expense of the ethical and legal principles and procedure they're supposed to protect. I mean, I was just naive, but I had no idea it was this bad. So I pass out, I send it to some, I send it to some publications, and I pass it out on the steps of his courthouse because I was pissed off. I was hoping he'd come out, maybe so I could, kick him in the head. Maybe he'd want to roll. I don't know. But I passed it out. I called the law director, a guy named Burdick, and said, here's what I'm going to do. Will this be a problem? I don't want to, get in the way of the court's business and time, place, and manner restrictions. And the guy said, no, you'll be fine. You'll be fine. Just kind of be polite. So I passed it out. A bunch of attorneys stopped and read it. So this was in April of 2007 when I passed out the editorial. And it's a very balanced editorial. I mean, it's not shrill, but it's frank. So 6 months later, I remember very clearly, I'm sitting in my place in Vermont, and the state police come in. I know the state police. I've helped them with, certain things. They needed favors, and I helped them. And I know them. And they said, gee, sorry, Bob, but we got to take you in. I said, why? He goes, there's an extradition warrant for you in Ohio for a third-degree felony. So, my bowels emptied. And I said, well, what is this? They said, sorry, Bob, we got to take you in. So they handcuff you, take you from your home, put you in a cell. You're sitting there. And then they called the prosecutor. And they said, here's what we have. Should we keep this guy in? Because Ohio wants to render him. He's going to be a nice long bus ride chained to the floor. So The prosecutor said, no, you don't have enough to keep him. Just, let him go. So they drove me home. They were all very nice. And I asked to see the paperwork. And because one of the sergeants knew me, he was a good guy, he just showed me the paperwork. And I couldn't believe what I saw. Ohio went to the grand jury and said that when I wrote, if you go back to 2003, when I wrote to the FBI, my application to get a gun, and I sent them the documents explaining that the statute under which I was convicted for improper storage of a firearm was a misdemeanor, after which the FBI agreed and said, yeah, you can have your gun. It's a misdemeanor. They said when I wrote on the document, I falsified a court document, which is a violation of a particular felony code. So, I couldn't believe it because, one, the code they cited was for alteration of a document, of an original document in the possession of the court clerk. Like, for example, suppose someone's in the court clerk's office and has access to driver's licenses, and they're falsifying them for their friends who may be, illegal aliens or people who need a license. Or suppose an attorney goes in to a court and asks to look at a file, then he changes the award from, $100,000 to 25 cents. It's for alteration of an original court document in the possession of the court clerk with the intent to commit a fraud. I said, guys, I started laughing in the police car. I said, writing in green ink to, supplement a court order, which is not an original, which with no fraudulent intent, which was, acknowledged by the FBI. They said, oh yeah, we saw you wrote on it, but it doesn't matter because, you're not changing a felony to a misdemeanor. No problem. I said, it's not a crime. And it's not the crime described in the warrant. So anyway, they're driving me home. The prosecutor says, they didn't have enough to keep me. So then 2 weeks later, the police come again. And the prosecutor said this time, okay, they do have enough to keep you now. And you're going to have to go to Ohio. And, maybe we can figure out a way that you don't have to go by bus, chained to the floor. So I went, I was really scared. I was scared. So I looked at the docket, the docket, the accusing docket, for the new criminal felony action against me. And I noticed that in June, remember I wrote the editorial in April. In June, there was a presentment to the grand jury, and I got a no bill. No one gets a no bill. No one. It just doesn't happen.
And I actually have to stop you for 1 second because I 100% I am trying to put this up. I in my entire law enforcement career, I've never seen, and what Bob's saying is right here. I don't know if my cursor is showing here. He gets a no bill. I have never seen that in a million years because you can pretty much, and I think Bob uses the verbiage, the same verbiage in his book, but you can indict a bologna sandwich, and I've never seen it. So I'm sorry. I just had to like make certain everybody knows and understands that I've never heard of it, never seen it, and that's what you get in a no bill.
No, thank you. I appreciate your help. Thank you. No, especially, coming from, someone who was a police chief who sees, indictments all the time and grand jury procedures all the time. So now it turns out that I said, well, okay, I got a no bill. Then they represented. Now, if they had new facts or something like that, a new crime, okay, they get to represent, but they represented on the same facts. And then they got a true bill. I said, wait, you cannot do that. You cannot represent the same, facts. And there's a brand new case, like I was, in June 2007, I got a no bill. Then in August of 2007, a case came down called Freilich versus Ohio Board of Mental Health, which said, if you represent, it is malicious prosecution, it is illegal, and the state is liable for damages. You cannot do that. I said, guys, I win. Just, drop this thing, would you? I made a motion, and they would have nothing of it. Ohio just didn't care. Didn't care. So I called some attorneys. I said, can you guys, help me with this? And I said, well, let's look into it. And then they say, no, sorry, we can't do this. And I said, wait a minute. You're a criminal attorney. I'm basically a no one. You can't help me? I said, no, sorry. So they had me come in for the, what is that called when you go in and cop a plea? Yes or no?
Arraignment or pretrial? Or?
Yeah, the arraignment. They had me come in for an arraignment. So I made an arrangement with the Vermont prosecutor, who was a very decent person, Joel Page. He is a prince. He said, well, listen, you stay in touch with us very closely, and we won't force you to be in custody when you go back and forth, from Vermont to Ohio. But you call us every time we want you to call us. I did. So I drove into Vermont. And I called the bail guy. I said, well, what's going to happen there when I get there? They have a bail commissioner. And he looked at my case and he goes, this doesn't make any sense at all. You got a no bill. This isn't making. So he goes, when you get here, I'm going to free you on your own recognizance. No bail, even though you live in another state. So I go in for my arraignment and say not guilty. Then, they put you in a cell and they hold you. And then I was arrested again the same day on falsified charges in Chagrin Falls. So I'm transferred to a cell in Chagrin Falls where I make bail. But that is also a falsified charge for an offense which was dismissed several years earlier. So I said, okay, there's obviously some very powerful people who want to make life miserable for me. So I get out of the jail, make bail in the cell in Chagrin Falls, and go back to Vermont and start making motions. Now, in the indictment, it says, on April 28th, 2003, I falsified an original document in the possession of the, according to the statute, I falsified an original document in the possession of the court clerk. Well, I sent them I made a motion to dismiss based on alibi. I had ATM receipts to prove I was in Vermont and New Hampshire for the several months before, after, and during April 28, 2003. I wasn't there, and I didn't do anything wrong anyway. So you make these motions, and the judge wouldn't rule on them. The judge was Michael Russo. He wouldn't rule on them. Now, according to the rules of superintendents for the courts of Ohio, a judge has to rule on a motion within 120 days. He wouldn't rule at all. According to Criminal Rule 8, you get pretrials where everybody shows, so you sort of show what you have. You're supposed to have a pretrial conference. They show their evidence, I show mine, and then you decide whether to go to trial or not. I made a motion for a pretrial hearing. They wouldn't give it to me. I said, wait a minute, guys. I get this. It's a rule. They wouldn't give it to me. So then here's what got really nasty. They call me in for a pretrial in November. You have to go to them. You have to go or you're cooked. Michael Russo's bailiff was a woman named Mary Pat Smith, who was filthy. She was nasty, cutting, impatient, strident. She said, you have to come to this thing. So I drive from Vermont to Ohio. I don't even see the judge. I'm sitting in a side room, and someone walks in, the prosecutor, and says, well, you want to take a plea? We'll give you a plea for a misdemeanor. I said, no, I didn't do anything wrong. Are you out of your mind? I go, okay, go back to Vermont. It took 5 minutes. I drive 1,400 miles for a 5-minute conversation. They can say, go back. So then they do the same thing in December. Drive in. Want to take a plea? Said no. Okay, go home. That's another one. They did the same, I think in December, January. They didn't drive in. Want to take a plea? No. So that's like 4,500 miles of driving for 15 minutes of conversation with the prosecutor. Then they say, okay, I said, I want a trial. Plus, I want my rule, I want the pretrial conference, and I want my, my motions decided. I have an alibi, I didn't do anything. I got a no bill. It's illegal to represent. I'd like, some response with respect to my, the legal standards and the legal rights I have. Absolute silence. So trial was set for early March in 2008. So I, once again, my, fifth trip. The interesting thing is, before this, I called WKYC and said, it's a long shot, guys, but I'm being, prosecuted on false charges. And the court system is not following its own rules, nor it's responsive to my defenses and rights. So I go there, drive all night, go there, and there's people with cameras setting up in the courtroom. Wow, I can't believe it. I got something. So I go in for the trial, and I'm ready to roll. I have all my evidence, all my briefs. And I just waited. I was there, at 8:30. The judge's courtroom seemed to open at 9, and I sat there, and sat there, and sat there all day until the court comes in at 4:30. They close, and security came to me and said, "You have to leave." And I said, "Wait, I have a trial today." No one's even spoken to me. I sat through several other hearings. The judge knew I was there. He knew exactly who I was. So, I go behind, the judge's, you sort of go behind, where the judge sits, and there's a door, and there's several offices where the judges have their office. So I go in there to say, go in his office and say, what's going on? And meanwhile, his bailiff shouts at me, "You're never allowed to go here." I go to the prosecutor's office, Bill Mason's office, and said, "What's going on?" And they said, "We're not allowed to talk about it." So I drive back to Vermont. That's my 5th round trip. So then they say, well, so they brought me in again in April, offered me a plea deal, round trip 6. I said no. Brought me in June. They scheduled another trial for June, when I drove in. And they say, well, do you want to take a plea? And I said no. And then they canceled the trial. And it turns in June, I needed abdominal surgery. Completely unrelated to, this thing. It just happened. I just needed it. And the pretrial that was scheduled for July was canceled. And they brought me back in August for a pretrial. And I said, no, I will not take a plea. Then they set trial again for October. And they said, and I said, Bob, this is like your 10th or 11th trip here. This is going to go on forever. Here's what we'll do. We'll let you off for a $50 fine if you confess to a misdemeanor. I said, my bar, I can't do that. My bar is going to, I'm going to lose my license if you do something dishonest like that. Fraudulently changing a court order, you're cooked, you're dead. And I said, I didn't do it. And he goes, well, Bob, this is like your 11th trip. The trials keep getting canceled. We'd hate to see you in an orange suit. So I was just exhausted. I'm still recovering from abdominal surgery. It was really, I just got the idea. So I said, okay, $50 fine, no probation. Okay, drop.
Folks, it's the future me. I just wanted to insert myself here because I wanted to make certain that Bob's point was loud and clear on this. This is a common tactic used by the Cuyahoga County Prosecutor's Office because the Cuyahoga County Prosecutor's Office just wants you to plea, and they will do everything in their power to make you plea. And in some cases, even with the help of the judges, especially in my case. I was ready to go to trial in May, and actually an open court was threatened that, hey, if you don't plead to what we've offered you, we're going to re-indict you, we're going to double your charges. And to be saying in an open court on the record in front of the judge was just absurd to me. But this is exactly what Bob is talking about. The guy lives out of state, so the prosecutors continue to have all of these pretrials, which I think are highly suspect, because I keep bringing this up because if you actually look at the dockets on the defendants' cases, it is always listed as the defendant wishing to put in a delay, essentially, for more discovery. And that's not the case. I can't even tell you the amount of times that I would contact my attorney and be like, hey, I didn't ask for this continuance. I didn't ask for this delay. I didn't ask for more time for discovery. I'm ready to go to trial. And it's just an accepted thing in Cuyahoga County. It totally blows my mind. But I want you to understand what Bob's frustration is in this point, is that the guy who lives out of state, he's now being called in multiple times. He is actually, I think after his 6th or 7th time of pretrials driving in from Vermont, he's ready to go to trial, and they simply just postpone the trial when he's there ready for trial. But it's a common tactic used by the Cuyahoga County Prosecutor's Office. Again, they don't want to go to trial. In most cases, they're not even prepared. They haven't even looked at the case. They didn't look at my case until like the second time around, almost 2 years later. And again, folks, when you indict someone, you should have your case ready. Otherwise, why are you indicting them? If you have no evidence and you don't even know what you're talking about, why are you indicting someone? Corruption of Cuyahoga County prosecutors at its finest. Going back to the interview with Bob.
Dead cocksuckers. Okay, you win. I'm exhausted. So, that's 14,000 miles of driving. The court never responded to any of my motions. I never got my pretrial conference. And what's worse is that every time I would refuse a plea bargain, the court docket said that the trial is continued at defendant's request, that's me, so he can get more discovery. Well, I never asked for a continuance. In the criminal system, continuances are required to be signed by the party requesting it and filed. I never filed anything. I never signed anything. What happened is I spoke to the public defender, who eventually ended up helping me on this case, a guy named Bob Tobick, who said, what happens is the criminal clerk of courts has a default setting, which assigns every continuance to the defendant, even though he didn't ask for it. So they don't spoil, so there's no defense to the right of speedy trial. And I said, who's the criminal clerk of courts? And I said, Mark Lime. And he said, Mark Lime. Turns out Mark Lime is now in jail on 36 counts of docket falsification. So that place is just filthy.
And Bob, I just wanted to, so this is actually my docket, and they're still doing it, Bob. So all of these, I could go back and I was actually threatened in an open court. I don't know how familiar you are with my case, Bob, but I was indicted on a bunch of charges. I was indicted on a bunch of charges that they figured out, we actually incorrectly charged the wrong Ohio Revised Code on this guy. They bring me in and they say, hey, if you make us go back and re-indict you, we're going to add more charges. So you better just take this plea. And this is all in open court with the judge present. And I'm like, well, you can continue to indict me 90 times because I didn't do what you're saying I did. But I just wanted to show on my docket what Bob's talking about. So each time this says pretrial set, pretrial held, it'll say pretrial at request of defendant. I never asked for any type of continuances on any of these pretrials right here. At the request of the defendant, reasons for continuance, ongoing discovery. I never requested any of those. And what Bob is talking about is the tolling of speedy trial. When someone's charged with a crime, a felony, there's, I believe it's supposed to be 270 days that you're supposed to have a trial. I mean, my stuff went on for almost 2 years, and they were able to do it because of what Bob's saying on his case, and they're still doing it. I never requested any of these continuances at the request of the defendant, reason for continuance. And I remember asking my attorney at some point, hey, why is this saying defendant's request? Because doesn't that stop the time? The legal term is toll. It stops your speedy right time because you're the one asking for the continuance. And my attorney's like, well, that's just how things are done in Cuyahoga County. And so, like you said, it was just mind blowing to me that this was occurring, because every month, this is what was stapled on my docket at the request of the defendant, and I never asked for a continuance once. So I'm sorry, I just wanted to show the viewers exactly what you were going through is still occurring today.
No, it's important. I mean, this is a conversation. It's not just me talking. I appreciate your contribution. Also, the right of a speedy trial, I think it has a 90-day limitation for trial. And the clerk of courts, Mark Lime, chief head of the criminal courts in Cuyahoga County, went to jail on 36 counts of docket falsification. So what happens is that, the legal system is a known system. And if you want to participate in this professional life, which is relatively lucrative, you have to accept the corrupt behavior, which is very serious, and the illegal use of unfair advantage. So anyway, so I signed this thing in 2008. I just got exhausted. After 11 or 12 trips, canceled trials, I just said, okay, $50. And I called my bar, and it turns out also while they were doing this, they sent an anonymous letter to the Washington State Bar, said, Bob has just been indicted on a third-degree felony. That means, disbar him, do something bad. So I get a call from my bar saying, what's going on? This is very serious. And I said, yes, it is very serious, but stay in touch with me because I didn't do anything wrong. I'm a hero. I did what, the attorneys are supposed to do, defend the Constitution and protect the integrity of the legal system. I exposed, bad practice. And as it turned out, Peter Junkin was later removed from office in Bedford Municipal Court. I mean, the FBI during the FBI raid started just during my case. Junkin was investigated. He's all over the plain dealer. Then in Bedford Municipal Court, a subsequent law director, his name's Schumann, Ken Schumann, was removed. Another judge Harold Jacobs, was removed. Bribes relating to prostitution. I mean, it was just, that place is a hole in the ground. You cannot participate in the legal system unless you are criminal, and people like me get in the way of income. So anyway, I get a call from my bar in 2008. They said, gee, Bob, this is really serious. And I said, no, I'm a hero. You should give me a medal. And so I didn't hear from them for 2 years. Then in 2010, I made a complaint to the Washington State Bar about it in an entirely unrelated matter. Turns out my brother in Seattle was embezzling from my mother's trust. My mother was, he just hundreds of thousands. So I had to start a legal action against him in Seattle. And it turns out his attorney, a person named Ronald Meltzer, was paying himself for the defense of my brother, who was a trustee of my mother's trust. He was paying himself for the defense of my brother, who was stealing from my mother's trust, from my mother's trust. Now, if my brother is stealing from the trust, my brother has to pay his own defense. You don't pay for the defense of someone who's stealing from you. So I called the bar and said, well, my brother's attorney is paying himself from my mother's trust. My brother's giving me access. This is, this violates the Code of Professional Conduct. So anyway, next thing I know, the bar, Washington State Bar, files an ethical complaint against me based on the correspondence from Ohio in 2008 saying I was convicted of a felony. So I say, bar, wait, why are you waiting 2 or 3 years from the time you knew of this activity to the alleged facts allege that I did something in 2003, which was very long ago, and your own rules say you have to bring a case within a year of knowing of bad activity. But, plus, you can't serve me. I'm in Vermont, Washington State. Your own rules say I can only be served if I'm in state or a resident, of which I was neither, even though I'm a member of the bar. So they held a hearing anyway. I filed, in the local federal court to enjoin it on the basis of procedural due process. And, they couldn't serve me. But the federal court said they were immune from suit, which they are not. I mean, there's a Ninth Circuit federal case, Anton Miller versus Washington State Bar. And the Ninth Circuit, which is the appellate district for the federal courts up there, specifically said, no, bar is not immune. They are an agent which can sue and be sued, but they don't care. People don't care about the law. That's why I'm bringing this up. The United States is under crisis of character. So they're having an ethical hearing against me in Washington State. I fly in, give them all my evidence, said, well, I didn't do anything wrong. I wasn't in Ohio at the time. I'm a wonderful person. You can't sue me anyway. You have no jurisdiction. So, go for the hearing. It's horrible. And then, bar made a motion. You can make a motion for finding of facts, sort of, it gives you an idea of how the hearing officer is going to rule. They made a motion to find that I had done, terrible things in Ohio and Vermont and Washington State. And the hearing officer said, no, we find that Robert Grunstein has not violated the Code of Professional Conduct anywhere. Not in Vermont, not in Ohio, not in Washington State. He has not violated the Code of Professional Conduct. Then they proceed to disbar me anyway. I mean, it's insane. So then I, say, well, how can you disbar me? And they go, well, you also didn't present any evidence. And I said, wait, I sent you my brief in advance. I sent you all my exhibits in advance. I entered my exhibits during the hearing. They were all numbered, and the hearing officer renumbered them to accommodate her numbering scheme. And they said, yes, yes, we know that happened, but you didn't make a formal motion to have them entered. And I said, there's no such thing as a formal motion. In addition to the federal case of Brady v. Maryland, a prosecutor has to acknowledge all exculpatory evidence of which it knows. And 2, the rules of professional conduct 3.3, 3.4, and 3.8 say a prosecutor must acknowledge all exculpatory evidence, however he knows of it. Now, if you read the transcript in my bar hearing, it's 76 pages in which my case in chief is presented, and all the exhibits are entered, numbered, acknowledged. And they said, well, you didn't make a formal motion, and there's no such thing. So everyone cheats, everyone lies. Washington State Bar committed a vendetta against me for filing in federal court to enjoin the hearing. So no one cares about right and wrong. The idea is income and control of ultimate decision-making capacity. So the United States is a wreck. It's a secret lie. And it turns out that almost all the jurisdictions behave this way. Some are less aggressive than others. But we're a nation in decline. I mean, if the polity, the administrative structure and behavior and belief of our legal system sustains this on a national basis, we're in trouble. The rot is extensive. We're going down. It doesn't happen overnight, but it's very bad. And the people who expose it get killed. And you end up dying alone in the dark.
And I think I think a lot of people don't. They honestly don't pay much attention, and until it seems like anybody that gets targeted by anybody in the system, those are the people that are affected, and it happens to everybody. It happens to good people, and again, I'm not opposed to prosecution, things of that nature. It's needed, but if you're ever become a target, you could be just anybody, and just like Bob's describing here, is that once you are a target, you just remain that target, and they will just continue to come at you with everything they possibly can. So I'm assuming at the end of your book, because there's been some time obviously since you've written it. I mean, I'm assuming you are still in the same status with the bar there, or
Yeah, what happens is I found, I've done some work, and I've I got some real help in different jurisdictions. So I should be admitted to another bar shortly, the next. So, but you don't want to go through what I went through. I mean, no one wants to. No one should. I mean, my virtue and trust in the legal system has been badly held against me, and I'm not the only one. But I just feel it's important to publicize it in a credible and documented fashion.
Yeah, I did. So there were some passages and we sort of covered them, but I just wanted to make sure. So, I don't know if I can share.
Oh, sure, anything.
Share this or. Well, no, I meant technologically. I don't know if I can do it here. I'm trying to figure out. All right, here we go. So you talk about, and I wholeheartedly agree, and this is one of the reasons that I flagged it. And you were talking about, I spoke with the attorney who did criminal defense. He said it was common for Bill Mason to schedule lots of pretrials to make a defendant miss work. People are normally fired after the fifth pretrial and can't afford to maintain a defense, even if they're innocent. And so did you have anything to expand on that? Because I wholeheartedly agree. This is one of the tactics of Cuyahoga County. And I have not seen this in any other county. I mean, most counties, when you have a pretrial, you have one or two pretrials, and that's it. And in Cuyahoga County, it just keeps stretching on. And I wholeheartedly agree with your analysis that this is the reason why they just want to keep stretching these pretrials out. So most people, I mean, they literally can't afford to live. They can't afford to support themselves. So they have no alternative but to plea.
Oh yeah, I mean it's just it's well documented. And matter of fact, one of the public defenders said, he said this is their this is what they do. One of the problems is, you have a large city, you have 36 judges, their dockets are overwhelmed, so the prosecutor has to resolve cases without going to trial. The idea is to avoid trial because it just takes too much time. And what you do is you get rid of the people who are the most vulnerable.
And I did flag some. I'm not sure. Double jeopardy. Oh, I think I was just asking, or there was a part that maybe I just needed clarification for myself. Again, trying to bring this up. So you're talking about, and I don't know if you really went into it on our podcast here, or show. So I thought it was a really valid point about the double jeopardy issue. Can you expand on that a little bit and explain it when you were going through the issue and all the Lakewood issue, and they were trying to basically bring it back up, I think is what the issue was.
Well, I guess double jeopardy was you cannot retry a case with the same facts and statutory violations. In order to retry a case, it has to have a new element not included in a prior case. And what happened is, I had to go, Lakewood Municipal Court was the one who discovered that I had sent their order to the FBI in order to get, the NICS office, the gun application office is in West Virginia, and the FBI office. The Lakewood Municipal Court was very concerned because they saw that I sent their order, and they initially had me come in. I was on unsupervised probation in Lakewood after the gun thing. And I said, "What does that mean?" It means nothing. But they said, "Well, you got to come in. We're going to have a hearing about the fact that you sent this thing to the FBI." So I, went in. We had a hearing, and nothing really happened. They said, I explained to them that I just, wrote on it, and that the prosecutor in Lakewood, there's nothing to prosecute. It's not a statutory violation. You're allowed to write on a copy, right. And it wasn't fraudulent. And the prosecutor who wanted to bring me in on violation of probation grounds didn't articulate a legal offense. He had no statutory code. It's like, it was just outrageous that the prosecutor just said he did something we don't like. He didn't have a statutory code. There was nothing in law, equity, or in criminal statute that I did wrong. He just, says, I don't like this. He wrote on an order. But it's not illegal. There was no fraud. There was no alteration of an official court document. So anyway, I had to go in 2003, 2004, I think. I had to go back to Lakewood and appear before the judge to explain what I sent to the FBI. And he said, okay. He's okay. And then nothing really happened. So that was the adjudication of the letter to the FBI. But the real problem is the lie to the grand jury. The fact that they said on April 28, 2003, I altered an original of a court document. I didn't. I wasn't in Ohio. And they got a no bill on it. The fact that when I, say, an alibi defense, I wasn't there. And that's not a constructive offense. The court wouldn't rule on it. I didn't get my, pretrial hearing. So double jeopardy was sort of, it's a nice little argument, but that was never contemplated. But the main thing was the unresponsiveness of the judge. He wouldn't rule on the motions. He wouldn't insist that I get the pretrial hearing. I mean, everybody's in it. It's like the whole county. I tried to get some attorneys. Eventually, Bob.
And you were describing before, and it was the same thing with me. My attorney had filed these motions. There were several motions, and same thing. I'm like, okay, or is the judge ever going to? I mean, it's 6, 7, 8 a year. I'm like, is the judge ever going to rule on this motion? And same thing. I was told, well, no, they generally hold it right before trial, and I'm like, what's this? How can you even have any type of defense when you don't know exactly what the rules are that you're going to be defending? I mean, is this evidence allowed? Is this evidence not allowed? I mean, that's sort of imperative to mount a defense. Are we going to be arguing about this evidence? I don't even know. I mean, and they wait right before trial so that essentially you have no ability to form any type of defense. But I also saw very interesting here because I halfway agree with you. I don't know, and I do know Bedford had a lot of issues. And I remember this judge you're talking about specifically, the case that he was eventually convicted on. But I found very interesting your reference to Parma, and I 100% agree. I mean, that's the formation of essentially Bill Mason and Mike O'Malley, and Parma just seems to be a city of a hotbed city of wickedness. But I didn't know if you wanted to expand on that from your book or.
Oh no, I'm happy to do so. I just didn't want to get too distracting because there were so many false charges and actions brought against me. What happened in Parma was during the litigation, if you remember, I was involved in a litigation against the homeowners association and the management company of the condominium I owned in Chagrin Falls. And once I got really mad at them, and so I, called the manager's office and sent him, left a really angry message. Really angry. So they went to the police with this message and said I was performing telephonic harassment and aggravated menacing. So, jurisdiction for Chagrin Falls is in Bedford Municipal. I drive in for the trial, get a judge. He's very pleasant, very matter of fact. Listened to it, and then he said, okay, not guilty, case dismissed. Okay, fine. Nice. I went home. It was dragged to have to drive in, but I had to drive in. I go home. Then, like 3 or 4 years later, when Cuyahoga County decided to bring the false charges for falsification of a document, I get a call from Joe O'Malley. The Joe O'Malley was sent to federal prison, who was the assistant prosecutor for I think sometimes Bedford, sometimes Parma. And said, well, we have this charge against you for aggravated menacing telephonic harassment. And I said, they were dismissed. Look at the docket. And he said, well, no, we're bringing them again in Parma. I said, how do you get jurisdiction in Parma? He goes, well, that's what we're doing, so you got to come in. So I go in, to Parma several times, and you have to litigate it there. I can't remember what happened. The judge, his name was Spanigal, this very incredibly likable person. Judge Spanigal's, he's just a hoot, very likable. But I think he fined me something. I can't remember what happened, but Joe O'Malley was bringing these new charges, old charges, again in a new court without, after they were dismissed, without making a motion to change venue. Even if they were live, you have to make a motion to change venue. There was no venue in Parma. I don't know what's going on. And anyway, when I had to come in for trial, I tried to get some attorneys to defend me, for this Parma business. And I called one guy, a guy named Sindelar. He used to be the prosecutor for North Royal, and he said, "Oh, this is nothing. You're not a bad guy. I had much worse. Send me $700, and I'll defend you." So I sent him the retainer. I get, he sent me the money back. He goes, "Sorry, can't do it. Can't do it. Sorry." I said, "Well, this is odd. He used to be the prosecutor there." And he said, the charges against me weren't very serious. So I called another guy named Spellacy. The Spellacy family is huge in Cleveland. They're judges, prosecutors. They run the place. And the guy says, "Oh, no, this is no problem. Just, send me some money." Then about a week later, he goes, "Lose my email, lose my telephone, never call me again, never contact me. I don't want the case." So I was on my own.
Well, I appreciate your time, Bob. Is there anything that I didn't touch on that you wanted?
No, I've probably been talking too long, but I hope it wasn't confusing. But you're going to see the way a county will organize against someone on, the police, the judges, the administration of the courts, including the chief criminal clerk of courts. These things can be organized on a countywide basis against someone based on a lie and illegal activity, and they don't give you your legal resources to defend yourself. It's bad, and it's happening in many places in the United States. We have to remodel the legal system from, as I said, the trustee of an ethical system to an income system which once you're a part of it, you're owned. And the idea is to maintain your income at the expense of the principals it's charged to protect, and never expose its defect. You expose its defect, you're dead, even if you're right. So I just hope maybe we can prolong the rate at which America is in delay and decline. Maybe I'm not the only person who's willing to stand up and say what is right. I'm not the only person. So maybe other like-minded people can come together and expose the legal system's defects, which are serious. So thank you.
All right. Well, fair enough. I thank you for your time, and hopefully, I don't know. Like I said, I was just trying to get more clarification with the records I had requested, but I'm assuming that
they hide things. They hide things. There's a duty. Oh, yeah. There's a duty to provide records, but if they're embarrassed, suddenly they can't find them, or there wasn't a record in the first place.
Yeah, for Solon not to have any record was mind-blowing. Chagrin Falls admitted that, hey, your name came up in the CAD, but there was nothing attached because of record retention, which I find extremely hard to believe. But I then followed up and said, hey, can I have a copy of your record retention policy, which they sent over? It's supposedly 7 years is what they have for incident reports. And I don't, again, being from the chief of East Cleveland, our records were attached to our, a CAD system. And I had records going all the way back forever, pretty much. So, I find it very interesting that they have nothing on you because of records retention.
On me, the most prominent records will be Chagrin Falls, Bedford, Parma, and City of Cleveland.
Yeah.
Anyway, thank you again.
Right, but if I get anything in, you mind if I follow up with you, or?
Oh no, follow up.
Any additional questions?
No. The most important thing about this is, can Bob, can he withstand scrutiny? It's very important to make yourself available to show that I'm right and I'm telling the truth, and it can be substantiated.
And I'll make sure in post-production or post-editing to obviously include all the links to your books and stuff. And if you want anything else, feel free to shoot it over to me and let me know. But like I said, I appreciate your time. And if you can just, I'm going to stop the recording. So if you can just make certain you wait until it says 100% there for me. All right, that's a wrap for episode 13. I appreciate everybody sticking around to the end here. There was one last message Bob wanted me to convey, and that was about Judge Calabrese. Apparently, Judge Calabrese and Bob went to the same law school. Apparently, they had a professor there. A guy by the name of Steve Barnes. Apparently, he had finished a work product for school and had lent it to Judge Calabrese, and Judge Calabrese asked for the paper for formatting help. Apparently the papers were identical. Again, I have no idea if that's true or not, but it's in Bob's book, and it's sort of par for the course as far as I'm concerned with what happens and what occurs in Cuyahoga County. We have a lot of things coming up next week. We're going to be dipping back into the Dawn Pasella case. Interviewed her parents. My media board's going way fast, way slow, way fast, way slow. I don't know what's going on, but able to interview Dawn's parents, and that will be coming up for episode 14. Don't forget about my special guest. That will be in July. That's coming up. I'm going to try to talk to him into doing a live format. I don't know if he's going to let that happen or not, but we're going to be smoking cigars, and you can too. As a matter of fact, I'm going to be going to the Leva event this week. And I'll bring along some Olivas, and that's what we're going to be smoking. Olivas, myself and my expert. Anyways, I appreciate you sticking around on the channel. And until next week, toodaloo.